Good day. My name is Louis Kruger from Schindler's Attorneys, and I'll be presenting a seminar today, Legal Update on Mortgage Bonds and Immovable Property, in line with the Continuous Professional Development Program of the Estate Agency Affairs Board. Our first topic relates to mortgage bond types and the registration procedure. Once instructions are received from a bank by the attorney to attend to the registration of a bond, there are a number of steps that have to be taken by the conveyancer. These steps generally are uniform. However, depending on the type of bond, these steps are usually taken in a different sequence. This seminar is aimed at giving you a brief outline of that process and understanding how mortgage bonds are effectively registered by conveyancers on behalf of the banks in the deeds office. The first type of bond are new bonds. These bonds are where a purchaser purchases a property and a bond is to be registered over that property. This could also apply where an owner of a property has an unbonded property and takes out a mortgage bond for the first time. Once the instruction is received by the conveyancer, usually electronically, the first step is that the conveyancer will contact the client to confirm receipt of the instruction. The attorney will at that stage get contact details from the client and also confirm that the details on the instruction, such as the property description, interest rates, etc., are correct. If there is a transferring attorney involved, these details will also be passed on to the bond attorney, who will then make contact with the transferring attorneys. The initial correspondence from the transferring attorneys to the transferring attorneys will be the request for the draft title deed of the property and any guarantees that are required. Bond attorneys will, once the documents have signed, forward them to the bank for confirmation that the documents are in order and that they may continue to proceed to registration. Once all the parties are ready, the transaction will be lodged. The process for new bonds is briefly as follows. The instruction is received from the bank. The attorneys contact the client to acknowledge receipt of the instruction, request contact details, FICA, etc. They'll also be provided with the contact details of the transferring attorneys so that contact can be made to request draft deed and guarantee requirements from the transferring attorneys. Once those documents are received, the bond attorneys are in a position to draft documents for signature by the clients. Once the clients have signed, guarantees are issued to the transferring attorneys. Once all standard and special conditions are met, the documents are submitted to the bank for their consent to proceed to lodgement. The bond is then lodged in the deeds office together with the transferring attorneys in a simultaneous transaction. The next type of mortgage bond is the further bond. This is where a client, an owner of a property, has an existing bond in favor of the bank and wishes to access further funds. The procedure is very similar. The instruction is received from the bank. The client is contacted to confirm and acknowledge receipt. Contact details are confirmed. In this instance, the original title deed must be forwarded to the bond attorney from the bank. Upon receipt of the title deed, documents are then compiled and clients sign the documents. Once all standard and special conditions are met, the documents are submitted to the bank once again for their approval. The bond is then lodged and registered in the deeds office, whereafter the bank will pay the proceeds to the client. The next type of bond is a switching bond. This is registered in an instance where a client has an existing bond with a financial institution but wishes to change banks or financial institutions. The existing bond is then cancelled and a new bond registered. The registration process is as follows. Receive the instruction from the bank. Once again, contact clients, confirm receipt of the instruction, request contact details and FICA. There's also then a request for cancellation figures on the existing bond from the existing bondholder. Upon receipt of the cancellation figures and the title deed from the existing bondholder, documents are drafted for the client to sign. Once the client has signed all the documents, the guarantees are issued to the attorneys attending to the cancellation of the existing bond. Once again, as in all instances, once the standard and special conditions are met, the documents are submitted to the bank to obtain their proceed to lodge. The bond is then lodged in the deeds office and registered simultaneously with the cancellation of the client's existing bond. The next type of bond is substitution of debtor bonds. This is where one owner in a property takes over the liability of another, such as in the instance of divorce. In this instance, the clients apply for one of the owners to take over the bond in their sole capacity. Again, instructions are received from the bank, client's contact details are confirmed, and documents are then awaited from the bank. Once the original title deed and mortgage bond is received, documents are drafted for the clients to sign. After the signature of the documents, and again once all special and standard conditions of the bank have been met, documents are submitted to the bank to lodge. It's important to remember that substitution is usually accompanied by a transfer of the half share of the other owner. Once the bank gives their proceed to lodge, and once the transfer is ready to be proceeded with, the bond is lodged and registered in the deeds office in the ordinary course. I've mentioned on a number of occasions that the banks often impose standard and special conditions when granting mortgage bonds. It is the responsibility of the client and the conveyancer to ensure that these conditions are fulfilled prior to the bond, in some instances being lodged, but most definitely before it is registered. Some of the standard conditions that we see typically in mortgage bonds are the signature of documents by the clients, complying with the bank's FICA regulations, providing debit order details, homeowners insurance, NHBRC registration documents, which is common in development bonds or where the property is less than 5 years old, electrical compliance certificates, and the payment of bank initiation fees. Examples of special conditions imposed by the bank: the first being submission of approved building plans, cancellation of a purchaser's existing bond or loan. This is usually required by the bank where there's an affordability issue, and for the client to be able to afford the current bond, an existing bond or personal loan will need to be settled. Cession of a life cover policy on the life of the mortgagor, the person taking the bond, to cover the bank's indebtedness in the event of the person's passing. Attendance of educational workshops offered by the banks. This is generally implied in bonds that are granted under a certain value, and often there's a request for various engineers' certificates or signature by suretyship by either a related or a third party, such as where the bond is being taken by a company or a trust. One of the bank's most strictest requirements is FICA. We, as conveyancers, are at all times obliged to comply with the bank's FICA policy 100%. Banks, estate agents, and conveyancers are all accountable institutions. This means that we are each individually responsible to comply with the FICA legislation. The bond cannot be registered in most instances until the bank has confirmed that the attorney may lodge or register the bond. This is generally submitted to the attorney electronically. It is really important to understand and appreciate that each bank has an internal, unique process which must be adhered to at all times when registering bonds. Strict compliance with these internal processes is required not only from the client, but also from the conveyancer. Failure to adhere to the bank's internal processes can result in lengthy delays and ultimately withdrawal of the bond by the bank. A proceed to lodge, again, is required in most instances. Please note that conveyancers have very little to no influence in the processing of documentation by the banks or the bank's internal processes. Now, I want to discuss a number of cases that have shaped our practice around mortgage bond registrations. The first is a case relating to suspensive clauses in sale agreements. In this case, Elof and Another versus Decker is a 2008 judgment. In this case, the plaintiffs, the mother and daughter, purchased an immovable property in Gordons Bay. The sale agreement was signed suspensive on them obtaining a bond by a certain date. Their bond was approved, but for a lesser amount than what the OTP required. The plaintiffs were thus of the view that the sale agreement had lapsed and requested repayment of their deposit. The seller admitted that the bond had not been approved for the correct amount, but it alleged that the plaintiffs accepted the lesser bond and that they have thus waived their suspensive condition. The seller was of the view that the sale agreement was still valid and binding. The seller thus rejected the purchaser's request for cancellation and a refund of their deposit. The court held that the mortgage bond clause in an agreement is inserted for the exclusive benefit of the purchaser. This is a condition that the purchaser may waive at any stage prior to its expiry unilaterally, in other words, without any agreement from the seller. The court also held that the seller in this instance had not proven that the purchaser had waived their rights under the bond clause. The court further confirmed the principle that the purchaser may waive their bond at any stage, as the condition has been inserted for their exclusive benefit. The court also held that where a waiver is undertaken, it should be clear and unequivocal. The court held that in this case, the defendants, being the sellers, had not established that the plaintiffs, the purchasers, had actually waived the suspensive condition, and thus the agreement had lapsed and the plaintiffs were entitled to the return of their deposit. The summary or importance of this judgment for us in the real estate sector is that, firstly, the agreement is suspended until the bond is approved. If the bond is approved by the due date and for the correct amount, the sale agreement will not lapse. If the purchaser obtains a lesser bond and wishes to accept that bond, the purchaser can unilaterally waive the condition, provided that this takes place before the expiry period of the bond. The purchaser's waiver must be clear and unequivocal, and, most importantly, must be done in writing. The purchaser can waive the bond clause in an addendum which is then signed by both parties, should the seller agree. The addendum must be signed once again before the expiry of the bond period. Any extensions to the bond suspensive period must be contained in an addendum and signed by both parties prior to the lapsing of the bond grant period. The next case relates to a bond granted on unusual terms and conditions. The case is Lategong and another versus Lelsey Middenhole Trollop, trading as Property Solutions. This case concerns an estate agent's claim for commission. The seller and purchaser entered into an agreement of sale for a property which was subject to the purchaser obtaining a bond. The bond clause provided that the bond was to be granted by the 23rd of November by a registered bank upon its normal terms and conditions. A further clause in the agreement provided that the bond condition would be deemed to have been fulfilled upon notification by the bank to the purchaser or his agent that the loan in question has been approved, regardless of any conditions attaching to such approval. On the 13th of November, the purchaser was granted a bond. However, the bond was granted subject to two special conditions. The firstly being the settlement of an existing bond registered over the property of the purchaser, thus implying that the purchaser would have to sell their existing property or find the funds to settle that existing loan. And secondly, that building of the home on the property must commence within 6 months from the bond registration. The estate agents resubmitted the bond application to the bank, and the bank removed the first condition on the 4th of December. No addendum was entered into at this stage to extend the date. You may recall initially that they were granted until the 23rd of November to have the bond approved. The purchaser thereafter cancelled the agreement on the basis that he was not granted the bond as contemplated in the agreement. The estate agents took the view that the suspensive condition relating to the bond finance had been approved, and thus they were entitled to their commission. The court in this instance held that the agreement had lapsed on the 23rd of November. The period had not been extended, and therefore the agreement was therefore null and void. Alternatively, the court held that the purchaser would be entitled to cancel the agreement, as the bond was not granted as envisaged in the agreement, and more so because it was not possible for the purchaser to fulfill the special condition that the bank imposed relating to either the sale of their existing property, settlement of that loan, or commencing construction within 6 months of the bond grant. In regard to the contradictory terms of the mortgage bond clause, which initially stated that the bond should be granted by the 23rd of November by a registered bank on their normal terms and conditions, and the further clause that stated that the bond would be deemed to have been granted regardless of any conditions which attached to it. The court held that the special conditions imposed by the banks were not the bank's normal terms and conditions, and as such, the suspensive condition was not fulfilled. The summary or the lesson for us to learn from this judgment is that the banks, often where the banks grant a bond subject to special conditions, these may not fulfill the suspensive condition. Bond grants must carefully be studied by agents and purchasers to identify any special or onerous conditions, and they must be acted upon accordingly. The next case relates to oral validity of variations. The case is Dreyer versus Libber and others, which is a 2010 judgment. In this case, the parties entered into the agreement for the sale of members' interests and loan accounts in a closed corporation. The agreement was subject to the purchasers obtaining a bond within 60 days. However, the 60-day period could be extended with the consent of both parties. In the event that the bond was not granted, the deposit paid by the purchaser would be refunded. The agreement also contained a non-variation clause, which stated specifically that no addition or variation to the agreement shall be binding on any of the parties unless it was reduced to writing and signed by the parties or their duly authorized representatives. Prior to the expiry of the 60-day period, the parties orally or verbally agreed to extend the period to the 9th of March. After the 60-day period had lapsed, but before the 9th of March, the purchaser cancelled the agreement on the basis that he could not obtain the required bond finance during the 60-day period that was initially agreed. As a result, he claimed repayment of the deposit. However, at this stage, he had only paid $120,000 of the $480,000 deposit required. The seller claimed that the purchaser's cancellation was not valid, as they had agreed to extend the bond grant period to the 9th of March. The purchaser again in turn alleged that the extension was not valid because the agreement contained the clause regarding non-variation and that any changes to the agreement had to be in writing and signed by the parties. Accordingly, the purchaser held that the extension granted to him verbally by the seller was not binding and the agreement had in fact lapsed. What the court held in this instance is that an oral agreement to extend a bond clause was an amendment to a material clause of the agreement. As the agreement contained the non-variation clause requiring any amendments to be in writing, the parties were not bound by this amendment. Accordingly, the purchaser was entitled to cancel the agreement and claim repayment of their deposit. The importance for us in this instance is that in future, and indeed as a matter of good practice, any changes, variations, or amendments to an agreement must be reduced to writing and signed by the parties. As a matter of good practice, again, just to highlight, this should be done whether a non-variation clause exists in the agreement or not. Our next topic relates to guarantees. You heard me referring to that term a number of times during the process of mortgage bond registrations. Where a conveyancer is appointed to attend to a property transfer, one of their important functions is to secure the payment of the purchase price of the property to the seller on registration of transfer. The purchase prices are secured by way of cash or by guarantees issued by a South African bank. Guarantees are usually due to be delivered within a certain period, and this is often set out in the sale agreement. What are guarantees? Guarantees are documents issued by a registered South African bank that guarantees payment upon the happening of certain events. For example, R1,000,000 will be paid to the conveyancer upon the registration of a transfer, the cancellation of existing bonds, and the registration of the purchaser's new bond over that property. All these events occur simultaneously in the deeds office. The guarantees are physically signed by representatives of the bank, who are often authorized by resolutions or powers of attorney. Once the matter is registered, the conveyancer who holds the guarantee will notify the bank of the registration to enable the bank to make payment into the nominated account. The source of guarantees. Where do the guarantees originate from? The source of guarantees usually depends on the terms of the agreement. In general, in our practice, mortgage bonds are our source of guarantees. The guarantees are then issued in terms of the bond that has been granted. In instances where a cash deal is entered into, the guarantee is issued either by the purchaser's bank, where the funds are held, or the funds are paid over to the conveyancer, invested in an interest-bearing account, and the conveyancer then issues a guarantee on that matter. Guarantees are generally a matter of trust. Purchasers often request to pay the purchase price on registration without the issue of a guarantee. The conveyancer's duty remains to secure payment of the purchase price, and therefore cannot rely on a mere undertaking by the purchaser to pay. Guarantees are not necessarily only a matter of trust, but rather practicality and contractual compliance. The next important aspect of mortgage bond registrations, which we've touched on briefly, is FICA. The Financial Intelligence Center Act is an act which was introduced into our law to assist with anti-money laundering in 2003. It's aimed at stopping money laundering and, in effect, terror financing. As mentioned before, estate agents, attorneys, and conveyancers, including banks, are all known as accountable institutions and are directly accountable to the Financial Intelligence Center. Accountable institutions must comply strictly with the FICA rules and regulations, which are set out in the FIC Act, and conduct the required verification of the client's identities. And there's a further responsibility to report and keep record of certain information obtained from clients. What information are we required to obtain from clients? We have to verify, in the instances of an individual person being a South African citizen and resident, their full name, their date of birth, their identity number, income tax number if they are registered, and residential address. This is achieved by obtaining a copy of the person's identity document, proof of residence, and proof of SARS income tax registration. Where we are dealing with individuals who are foreigners or non-residents, we have to confirm their full names, date of birth, nationality, passport number, income tax number if registered with SARS in South Africa, and their residential address. This is achieved by obtaining a copy of their passport, SARS confirmation of income tax registration, and proof of residence. In the event of dealing with companies or closed corporations, it is our responsibility to confirm their registered name, registered number, their registered address, confirmation of the name under which business is conducted, the address from which the company operates its business, their income tax and VAT registration numbers if they are registered and if these are issued, and then each member of the closed corporation or director of a company must be FICA'd as per the individual requirements mentioned earlier. In the event of partnerships, the name of the partnership must be proven, and the full names of each of the individual partners must be obtained, and FICA verification must be conducted as per individuals. In the event of dealing with a trust, we have to confirm the registered name, the registered number, the address of the master's office where that particular trust is registered, their income tax number if issued, then FICA for the founder and each of the trustees, including details of how beneficiaries are determined. This information is obtained by obtaining copies of the letters of authority, the SARS income tax proof of registration, and a copy of the trust deed which sets out how that trust is structured. The question is always, when must documents be obtained from clients? Prior to acceptance of a mandate is the first instance, and thereafter, the agent and conveyancer and banks must take reasonable steps to maintain correctness of that particular information which are susceptible to change, such as a person's residential address. Purchaser FICA is required only before the offer to purchase is concluded. How long must all the documents be kept for by an estate agent, attorney or bank once obtained from the client? The general rule is that these documents must be kept for at least 5 years. The documents to be kept are all FICA forms, questionnaires that the clients complete, a copy of the signed and completed mandate, the sale or lease agreement, and then all documents obtained by you in conducting the verification of the client's identity. Suspicious or unusual transactions must be reported to the FIC. There's an obligation on estate agents to report these transactions. A suspicious transaction will be one where the transaction itself raises questions or gives rise to discomfort, apprehension, or mistrust. Generally, our gut will be indicative. These unusual or suspicious transactions must be reported to the Financial Intelligence Center as soon as possible, but not later than 15 days once you have become suspicious. Cash threshold reporting is another instance where, as accountable institutions, we're obliged to report cash transactions where payment of 25,000 Rand or more is received by an estate agent, bank, or attorney. If 25,000 Rand or more cash is received, you have 2 business days from date of receipt of those funds to report this instance to the FIC. We've now come to the end of our presentation, and I trust that you found this beneficial. Please remember to complete the 10-point multiple choice questionnaire at the end of this presentation. Thank you.